Welcome back, everyone. Today we're here to break down the May 29th, 2025 Supreme Court opinion in the case called Seven County Infrastructure Coalition versus Eagle County. This case centers on environmental and administrative law. Please note that this summary is read by an automated voice. I apologize for any mispronunciations. This case involves an ambitious project, an 88-mile railroad line in Utah designed to transport crude oil. Now, when a project like this gets proposed, federal law requires an environmental impact statement, or EIS. Think of an EIS as a comprehensive report that federal agencies create to analyze the potential environmental effects of a proposed action. It's meant to inform decision makers and the public about what might happen to the environment. In this particular situation, the U.S. Surface Transportation Board, the federal agency overseeing railroads, prepared a massive EIS for the Utah rail line. The board looked at the direct environmental effects of building and operating the railroad itself. However, the board didn't fully analyze some broader potential effects, specifically the impacts of increased oil drilling at the start of the process, or the impacts of increased oil refining at the very end of the process, far down the line, along the Gulf Coast. The board reasoned that these upstream and downstream activities were too speculative and outside its direct regulatory authority for the railroad. Now, a lower court, the D.C. Circuit, disagreed. That court said the board had impermissibly limited its analysis, claiming these broader effects were reasonably foreseeable. So, the D.C. Circuit actually halted the project approval, saying the environmental review was insufficient. This is where the case got very interesting and headed to the Supreme Court. The question presented for Supreme Court resolution is whether the National Environmental Policy Act requires an agency to study environmental impacts beyond the proximate effects of the action over which the agency has regulatory authority. The court reversed the D.C. Circuit's ruling. The Supreme Court said that the D.C. Circuit didn't give the board the substantial judicial deference that agencies are supposed to receive in these types of cases. The court clarified that the National Environmental Policy Act, or NEPA, the law requiring these environmental reports, is primarily a procedural statute. NEPA requires an agency to report on environmental impacts, but it doesn't dictate specific environmental outcomes or impose absolute restrictions. Justice Kavanaugh delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, and Barrett joined. Justice Sotomayor filed an opinion concurring in the judgment, in which Justices Kagan and Jackson joined. Justice Gorsuch took no part in the consideration or decision of the case. I'll now give a summary of the majority and concurring opinions and follow that up with possible case implications.
Justice Kavanaugh's majority opinion. Under federal law, new railroad construction and operation must first be approved by the U.S. Surface Transportation Board. In 2020, the Seven County Infrastructure Coalition applied to the board for approval of an 88-mile railroad line connecting Utah's oil-rich Uinta Basin to the National Freight Rail Network, facilitating the transportation of crude oil to refineries along the Gulf Coast. As part of its project review, the board prepared an environmental impact statement, EIS, that addressed significant environmental effects of the project and identified feasible alternatives that could mitigate those effects, as required by the National Environmental Policy Act, NEPA. The board issued a draft EIS and invited public comment. After holding 6 public meetings and collecting more than 1,900 comments, the board prepared a 3,600-page EIS that analyzed numerous impacts of the railway's construction and operation. Relevant here, the EIS noted, but did not fully analyze, the potential environmental effects of increased upstream oil drilling in the Uinta Basin and increased downstream refining of crude oil. The board subsequently approved the railroad line concluding that the project's transportation and economic benefits outweighed its environmental impacts. Petitions challenging the board's action were filed in the D.C. Circuit by a Colorado County and several environmental organizations. The D.C. Circuit found numerous NEPA violations arising from the EIS. Specifically, the D.C. Circuit held that the board impermissibly limited its analysis of the environmental effects from upstream oil drilling and downstream oil refining projects, concluding that those effects were reasonably foreseeable impacts that the EIS should have analyzed more extensively. Based on the deficiencies it found in the EIS, the D.C. Circuit vacated both the EIS and the board's final approval order. Held, the D.C. Circuit failed to afford the board the substantial judicial deference required in NEPA cases and incorrectly interpreted NEPA to require the board to consider the environmental effects of upstream and downstream projects that are separate in time or place from the Uinta Basin Railway. A. NEPA ensures that agencies and the public are aware of the environmental consequences of certain proposed infrastructure projects. As a purely procedural statute, NEPA does not mandate particular results, but simply prescribes the necessary process for an agency's environmental review of a project. Some federal courts reviewing NEPA cases have assumed an aggressive role in policing agency compliance with NEPA and have not applied NEPA with the judicial deference demanded by the statutory text and the court's cases. When, as here, a party argues that an agency action was arbitrary and capricious due to a deficiency in an EIS, the only role for a court is to confirm that the agency has addressed environmental consequences and feasible alternatives as to the relevant project. Further, the adequacy of an EIS is relevant only to the question of whether an agency's final decision, here to approve the railroad project, was reasonably explained. Judicial deference in NEPA cases extends to an agency's determination of what details are relevant in an EIS. While NEPA requires an EIS to be detailed, and the meaning of detailed is a legal question, what details need to be included in any given EIS is a factual determination for the agency. The textual focus of NEPA is the proposed action, the project at hand, not other separate projects. Courts should defer to agencies' discretionary decisions about where to draw the line when considering indirect environmental effects and whether to analyze effects from other projects separate in time or place. In sum, when assessing significant environmental effects and feasible alternatives for purposes of NEPA, an agency will invariably make a series of fact-dependent, context-specific, and policy-laden choices about the depth and breadth of its inquiry, and also about the length, content, and level of detail of the resulting EIS. Courts should afford substantial deference and should not micromanage those agency choices so long as they fall within a broad zone of reasonableness. Even a deficient EIS does not necessarily require vacating an agency's project approval, absent reason to believe that the agency might disapprove the project if it added more to the EIS. B. Contrary to the D.C. Circuit's NEPA analysis, the board's determination that its EIS need not evaluate possible environmental effects from upstream and downstream projects separate from the Uinta Basin Railway complied with NEPA's procedural requirements, particularly NEPA's textually mandated focus on the proposed action under agency review. While indirect environmental effects of the project itself may fall within NEPA's scope, even if they might extend outside the geographical territory of the project or materialize later in time, the fact that the project might foreseeably lead to the construction or increased use of a separate project does not mean the agency must consider that separate projects' environmental effects. This is particularly true where, as here, those separate projects fall outside the agency's regulatory authority. CC NEPA does not allow courts, under the guise of judicial review of agency compliance with NEPA, to delay or block agency projects based on the environmental effects of other projects separate from the project at hand, reversed and remanded.
Justice Sotomayor concurring opinion. The National Environmental Policy Act improves agency decision-making by requiring agencies to consider environmental impacts for which their decisions would be responsible. I agree with the court that the Surface Transportation Board would not be responsible for the harms caused by the oil industry, even though the railway it approved would deliver oil to refineries and spur drilling in the Uinta Basin. I reached that conclusion because under its organic statute, the board had no authority to reject petitioner's application on account of the harms third parties would cause with products transported on the proposed railway. The majority takes a different path, unnecessarily grounding analysis largely in matters of policy. Accordingly, I write separately to explain why the result in this case follows inexorably from our precedent. NEPA requires agencies to prepare and publish a detailed statement reviewing the environmental impact of any major federal action. That action-forcing requirement serves dual purposes, ensuring both that an agency considers a project's environmental consequences before deciding whether to approve it, and rendering the agency publicly accountable for environmental harms it decides to tolerate. The point, as this court has recognized, is not merely that an agency produce a report, but that environmental concerns be integrated into the very process of decision-making. In that way, NEPA's procedural requirements advance Congress's aim that the federal government use all practicable means to ensure that the nation may fulfill the responsibilities of each generation as trustee of the environment for succeeding generations. Because NEPA's central aim is to improve agency decision-making, an agency need not consider every conceivable environmental consequence of a proposed federal action. Rather, agencies need only analyze environmental impacts for which their decision would be, at least in part, responsible, a requirement akin to the familiar doctrine of proximate cause from tort law. An agency is not responsible for environmental impacts it could not lawfully have acted to avoid, either through mitigation or by disapproving the federal action. Nor is an agency responsible for impacts that, though technically avoidable, are so causally attenuated from or ancillary to the agency's statutorily assigned tasks that it could not reasonably have been expected to consider them as part of its decision-making process. Together, these limitations serve to keep the scope of the agency's review targeted to environmental impacts it is well positioned to address. Precedent makes these abstract principles concrete. In Public Citizen, this court evaluated the Federal Motor Carrier Safety Administration's environmental analysis of regulations, establishing an application process for Mexican motor carriers who wanted to operate in the United States. The application system itself had only minimal environmental impacts related to anticipated roadside inspections of the Mexican trucks and buses. Yet the agency developed it at the direction of the president, who had decided to lift a long-running moratorium on Mexican carriers' operation in the United States following the system's completion. Thus, promulgation of the agency's regulations would enable a substantial influx of new trucking, which in turn would have major environmental implications. This court concluded that though the agency's regulations would be a but-for cause of the new trucking, it did not need to consider the related environmental impacts because it had no authority to prevent them. After all, the decision to lift the moratorium had been the president's, not the agency's, and the agency could not lawfully refuse to issue its regulations in order to block the president's decision. The agency had no means to prevent, and thus was not responsible for, the consequences of lifting the moratorium. Hence, NEPA did not require it to analyze those consequences. The court's decision in Metropolitan Edison illustrates the companion principle. Some environmental impacts are connected to an agency action by way of so attenuated a causal chain that the agency may reasonably dismiss the mass ancillary to its decision. In Metropolitan Edison, the court considered whether the Nuclear Regulatory Commission had to analyze not only the risk that a proposed nuclear plant would cause an accident, but also the psychological concern nearby residents might experience when they learned about that risk. Although the psychological concern would be caused by the nuclear plant, the court held that NEPA did not require the agency to consider it. That makes sense. Preventing nuclear accidents is a core element of the Commission's statutory task. Preventing psychological distress is not, because the agency could reasonably disregard psychological distress in deciding whether to approve a power plant. It could disregard that risk in its environmental analysis as well. As these cases show, the dual limitations on an agency's duty to consider information under NEPA yield a rule of reason, which ensures that agencies determine whether and to what extent to prepare an EIS based on the usefulness of any new potential information to the decision-making process. NEPA requires consideration of environmental impacts only if such consideration would result in information on which the agency could act. Consistent with these principles, judicial review of an agency's environmental impact statement involves a two-step analysis. First, courts must consider the grounds on which an agency may rely under its organic statute to modify by mitigation or reject a proposed federal action. If the organic statute precludes consideration of a particular issue, the agency may set it aside for purposes of its NEPA review as well. That is the rule of public citizen. Second, if an agency decided not to review an environmental impact because, in its judgment, the impact was too causally attenuated from the question at hand, courts must ask whether the agency acted arbitrarily in doing so. That deferential standard of review is appropriate here, as it is across substantive areas of administrative law, because agencies have unique expertise, often of a scientific or technical nature, relevant to applying a regulation to complex or changing circumstances. Thus, as the majority points out, agencies often are better equipped to assess what facts are relevant to their own decision than a court is. This case provides no occasion to consider the second step because the question presented is resolved at the first. The board twice decided it lacked authority to reject railway applications on account of the ways in which third parties would use the products transported on the proposed rail line. Each time, the agency cited public citizen to justify its decision not to analyze further the environmental effects of oil drilling and refining made possible by the railway. Review of the board's organic statute, the Interstate Commerce Commission Termination Act, confirms the board's understanding of the scope of its review. As common carriers, railroads subject to the board's jurisdiction are required to provide transportation or service on reasonable request to any person or commodity. In addition, the Act contains a clear presumption in favor of approving new railways. And of the 15 statutory policies the board must consider in the exemption process, not one concerns the anticipated use of commodities that will be transported on the proposed railway. Unlike the board, meanwhile, other entities do have authority to approve oil and gas development projects and to regulate the effects of refining. All this suggests, as the board concluded, that the board could not have rejected petitioner's application in order to prevent the harmful effects of oil drilling and refining. Short of rejecting the railway entirely, Moreover, the common carrier mandate prevented the board from mitigating by limiting the transport of crude oil, the railway's spurring of the oil industry. The environmental respondents concede that the board correctly understood the scope of its decision-making authority. Instead, they argue that the board should have analyzed even environmental impacts it could not lawfully prevent. Yet Public Citizen squarely forecloses that position. Even a foreseeable environmental effect is outside of NEPA's scope if the agency could not lawfully decide to modify or reject the proposed action on account of it. NEPA thus did not require the board to consider the effects of oil drilling and refining. Under NEPA, agencies must consider the environmental impacts for which their decisions would be responsible. Here, the board correctly determined it would not be responsible for the consequences of oil production upstream or downstream from the railway because it could not lawfully consider those consequences as part of the approval process. For that reason, I concur in the court's judgment reversing the D.C. Circuit's holding, requiring the board to consider in further detail harms caused by the oil industry.
Case implications. The Supreme Court emphasized that NEPA's main purpose is to ensure agencies are informed about the environmental effects of their proposed action. The court suggested that requiring agencies to analyze separate projects, especially those in different times or places, and those outside an agency's direct regulatory control, would overburden the environmental review process. The court also noted that overly aggressive court oversight has often led to significant delays or even blocked important infrastructure projects. Now, let's talk about the interplay between the majority opinion and a concurring opinion in this case. The majority opinion sets out the primary reasoning for the court's decision. A concurring opinion, in this instance, agreed with the outcome that the D.C. Circuit's decision should be reversed, but offered additional or slightly different reasoning. The concurring opinion here strongly emphasized that the board could not lawfully consider the environmental consequences of oil production and refining because those activities fell outside the board's legal authority to approve or deny. This perspective reinforces the majority's point about the limits of an agency's responsibility under NEPA by highlighting that an agency cannot be held accountable for impacts stemming from actions it has no legal power to regulate or prevent. This serves to underscore the idea that NEPA's requirements are tied directly to an agency's specific decision-making authority. Crucially, this decision also attempts to align with a broader shift in how the Supreme Court approaches the review of agency actions. Several times, the majority cited its recent decision in Loper Bright Enterprises versus Raimondo to highlight an important distinction in how courts review agency actions. In Loper Bright, the Supreme Court explicitly overruled the long-standing Chevron doctrine, which had previously required courts to defer to an agency's permissible interpretation of an ambiguous statute, even if a court might interpret the statute differently. The Loper Bright decision clarified that the Administrative Procedure Act, the foundational law for how federal agencies operate, requires courts to exercise their independent judgment in deciding all relevant questions of law. This means courts are reclaiming their primary role in determining the precise meaning of statutes. While an agency's factual findings or its exercise of clearly delegated discretionary authority may still receive respect from courts, Loper Bright emphasizes that agencies have no special competence in resolving statutory ambiguities themselves. The implication of both Loper Bright and this Eagle County case, when viewed together, may be a move toward more judicial oversight of agency interpretations of law, while still allowing agencies discretion within the clear bounds of their statutory authority. As the lower court decisions make clear, this may be a difficult line to draw. That's a summary of the May 29, 2025 Eagle County decision and its broader context within environmental and administrative law. Thank you for joining.